Tase. I'm Dr. Rebecca Major, and I want to talk a little bit about Daniels for a few minutes. So, one thing about the Daniels case is it has been transformative for the relationship between Indigenous peoples and the Crown. However, it didn't actually change the people. And this is something that's important to remember because a lot of times we see people associating identity with how legislative constructions have developed. But this is not necessarily how people see themselves. It's more how people see ways to access rights associated with identity. So, understanding self for how Indigenous peoples perceive identity is actually at odds with the constructed view of Indigenous peoples. In our house, we've always spoken openly with our son, and so it was no surprise when we were mentioning one day about what was happening with the Daniels case. And at 4 years old, his first reaction was, "Does that mean I can hunt?" Because he understands that identity and rights are regulated through the government, but that's not how he defines himself. And we figured that out one day at another time during the summer of 2015, during the evacuation because of the fires in northern Saskatchewan, that we were having conversation about the word Indian, and he got very offended and was like, we're not Indian. And I was explaining this is a legal definition. And I asked him, I said, well, what does that mean to you, the word Indian? And he went like this with his fingers and then put his fingers up behind his head as though he's perceiving an identity that comes out of cartoons. And so he did not understand his Métis identity connected to this stereotype or this legislated understanding of Indian, but did understand that part of his identity meant that he needed a legal apparatus to access rights. So it's really important to understand how we've made advances as Indigenous people through court systems on the basis of identity and asserting identity, but that doesn't actually change the substance of who the people are. Now, when looking further into this and looking at the case, it's important to first start with who is Harry Daniels. So looking back, there's actually a long history of Harry Daniels with the Congress of Aboriginal Peoples, because he started off originally with the Native Council of Canada. That is the root organization of where CAP comes from. So at the national level, Harry Daniels was involved in constitutional discussions, and Métis people were represented under his leadership with the Native Council of Canada. He was a Saskatchewan Métis political activist, and he began his career in Alberta in the 1960s, but is widely recognized for the contribution he made, along with other Métis and Non-status people from Saskatchewan, in having Métis rights recognized in the Constitution Act from 1982. So, as the Native Council of Canada had received 2 seats for the constitutional discussions, Daniels gave 1 seat to the Native Women's Association at the time because they were fighting for gender equity, and he gave the other seat to the AMSIS group that was being represented by Jim Sinclair. Now, although Daniels remained active during constitutional discussions, during that time, Sinclair became a principal spokesperson for Métis and Non-status peoples. So over the past few decades, the Congress of Aboriginal Peoples has worked as a lobby group to advance the rights of Indigenous peoples. In the later years, Daniels returned to the helm of CAP and became notable for that he advanced prior to his death in 2004. Now, the Daniels case is groundbreaking for Métis and Non-status peoples for several reasons. First, it provides recognition and offers protections by the Crown, such as the government's fiduciary duty. Second is the recognition is based on a collective identity and expands the individuals for whom the government's responsible. And third, instead of being derived from colonial institutions, Indigenous identity, it was more community-based and formed at least in part by Indigenous worldviews. So the Daniels case was supported by CAP financially, and although CAP is an organization and not a governing Indigenous community, these organizations actually often provide support to Indigenous peoples as they work to shift the Indigenous position in policy and institutions. And so these organizations are essential in making these advancements. So in other words, these changes now have occurred because Indigenous people have fought for them, and it's not because Canadian attitudes have changed. but it's because of the support mechanisms in place for advancing rights. So where this case began, in 1999, Harry Daniels and co-applicants Leah Gardner and Terry Judry, both of whom were non-status First Nations people, with Harry being Métis, launched the Daniels case against the federal government. So in their case, they sought 3 declarations that Métis and non-status were to be defined under Section 9124 of the British North America Act, that the Crown had the fiduciary responsibility for Métis and non-status peoples, and that Métis and non-status people had the right to be consulted with and negotiated with in good faith by the federal government, as well as on a collective basis through any of the representatives of their choice. And they wanted their rights respected and the interests of the needs of people also respected. So being recognized as quote unquote Indian in the British North America Act would have broader implications for older legislation and policy in which there was no distinctions made between Indian, such as First Nations, Inuit, and Métis. Originally, when the British North America Act was developed, there was nothing to use other than the word Indian. And it wasn't until later that we started to see the words half-breed and Métis arise. So anybody who was Indigenous at the time of 1867 then would now be recognized as being applicable to the word Indian. And this is not that different from R versus Eskimo in 1939, when the federal government became responsible for the Inuit, recognized as Indians as per the British North America Act 1867. So now there is this idea that there's this rights-based identity, and this rights-based identity implies that other policies and legislation apply to these populations when referred to as Indians. The only thing that is the exception is the Indian Act that was established in 1876, because it actually explicitly says it does not apply to Métis people. The Daniels case was heard at the federal trial level January of 2013, and it was ruled that Métis and non-status people were Indians as per Section 9124, and therefore a federal responsibility, which is implied through the constitutional designation. So the federal government appealed the case in October of 2013, and the non-status were dropped from the definition at the appeal case April of 2014. Now, both the appellants and the defendants appealed to the Supreme Court of Canada, and the Supreme Court heard the case October 2015, when parties that later joined the case, such as the Métis National Council, were granted intervenor status. Now, the Supreme Court decision came down on April 14th, 2016. It specified agreement with the trial judge, reading that the first declaration dismissed the second and third declarations, and they also dismissed the cross appeal by the federal government. So the courts explained that there was no need to make a distinction regarding Métis and non-status First Nations identity, as the group is regarded collectively as Indians under 9124. Now, this decision is considered a vindication for Métis people, as the case makes Indigenous groups in Canada equal. Métis and non-status people have been in this, what was known by the judge as a jurisdictional wasteland, while fighting for recognition and jurisdiction of rights had already been given for First Nations people. So this engagement of the institutional process by going through courts, the Indigenous people have vastly expanded identity-based rights and unsettling the government's goal of certainty and broadening responsibility. So today, when we discuss identity rights, Métis people in Canada describe the Daniels case as being critical and precedent-setting. They also refer to the Powley case. So Métis use varying signifiers for identity. It depends on the cultural grounding. So for example, many Northern Métis continue to hunt, fish, and trap as part of their cultural traditions. And this is why Powley was so significant for Métis and non-status people. As well, with the hunting, fishing, and trapping is also important for people that are in the South. And as such, many have actually participated in staged hunts as a way to advance rights. However, there are other ways that Métis people formulate identity, and for some, their identity is related to script and land that has remained in family for generations. For others, their identity is related to the connection to road allowance communities, and for some, like my family, it's just simply daily activities that help us recreate culture and identity through things like land-based foods and just just everyday possessions that exist in the home, which can be rag rugs and other types of community interaction that, are engaged in. So it's this connection to community that's actually pivotal. So Métis leaders will celebrate this Daniels case as a legal victory, and it's perceived that way because of the imposition of Indigenous worldview on identity and the changing standards. So inclusion of Métis people in Section 35 of the Constitution Act as one of the 3 Indigenous people has been an advancement over time. But the problem has been that the federal government has taken no formal responsibility for Métis and non-status people. So that's why Daniels becomes such an important case. The Métis and non-status First Nations people have argued that at the time that there was no distinction, and they were able to win that argument. And the case centered around the legal distinctions of identity that's been created by the federal government through legislation, and what separated First Nations and Métis people as Indigenous peoples, so aside from, culture and community, but looking at it from the legal perspective. Now, this case has changed the concept of Indians based on Métis perceptions of identity in the historical sense, and the argument has been based on the lack of historical distinction. So today, when we're looking at how Daniels can be implemented, we also have the commitments that were made by the Trudeau government with the 10 principles with interacting with Indigenous groups. So the 10 principles include in the last one, distinction-based approach. The government of Canada recognizes that they need to have this distinction-based approach to make sure that unique rights, interests, and circumstances of people are acknowledged, that things are implemented properly. The problem is at this point, based on actions, this commitment is questionable with recent developments in Indigenous Crown relationships. We've seen some problems in the last year or two prior to COVID, as well as during COVID. There's been situations that arose where we see that institutions are still strongly in place, where conversations are still happening around people as opposed to with people, and that there's still much work to be done in this area. So until that time, we still continue to see the status quo of institutional procedure that's enduring.